A DUI case always starts, but seldom stays, as a C misdemeanor. A C misdemeanor charge of DUI means the state has alleged a person drove while intoxicated or with a blood alcohol concentration of 0.08. A C misdemeanor is punishable with up to 60 days in jail and a $500 fine. Now, the next step up from the C misdemeanor is an A misdemeanor. A DUI can graduate from a C misdemeanor to an A misdemeanor if the intoxicated driving is alleged to have involved the element of endangerment, or if the BAC is above 0.15. But what does Indiana mean by endangering a person? This is one of the most common questions I'm asked on a daily basis, and there's no simple answer, as this truly is a legal gray-ish area. It is unquestionable that being stopped at a checkpoint does not rise to the level of endangerment, nor does having a broken license plate light. And Indiana law currently seems to suggest that speeding at 15 miles per hour or less within city limits is not endangerment, but there's also case law suggesting that more than 15 miles per hour over the speed limit within the city is endangerment. Crossing the double yellow lines is clearly endangerment, unless perhaps someone was dodging a pothole. Now, swaying within one's own lane of travel is oftentimes sufficient for endangerment, but every construction worker who's ever worked on an honest day in their life will tell you there's no such thing as a straight road. Some states even acknowledge that it's actually impossible to drive in a straight line because the earth is round. So was one swaying in an endangering way, or was that person simply correcting course on an imperfect highway? Now, what about the requirement that even if there was bad driving, a person be endangered? Well, the person referred to in the law does not actually have to have been endangered, but simply could have been endangered by the defendant's driving. And this person doesn't actually need to have been in the car with the defendant or even have been another motorist on the road. It is enough that even a police officer was endangered, and even in the absence of literally any person besides the driver, sometimes a person's driving can be bad enough where they endangered themselves, crossing double yellow lines and whatnot. So the person requirement is fulfilled by the presence of the passenger, other motorists, the police officer, and even the defendant, him or herself. The person requirement is a very low bar indeed for the state of Indiana to prove. An A misdemeanor is punishable by 1 year in jail and or a $5,000 fine. Now, the next step above an A misdemeanor is there's various levels of felony. The most common reason a DUI case is a felony is because the person currently charged with the DUI case has a prior conviction within the last 7 years of being charged within the current offense. It does not make a difference if the arrest for the previous DUI was more than 7 years ago. The only thing that counts is if the conviction was in the previous 7 years. In the event the person has a DUI conviction within the 7 years of the current DUI arrest, Indiana will charge that person with a level 6 felony, punishable up to 2.5 years in jail and or a $10,000 fine. Now, not as common, but just as serious is if there's a passenger under the age of 18 in the vehicle. If a person is charged with DUI OVWI with endangerment or a BAC above 0.15 and there is a passenger under the age of 18 in the vehicle, Indiana will charge that person with a level 6 felony, punishable, again, 2.5 years in jail and or a $10,000 fine. And that's true even if the driver has no criminal history. Lastly, a DUI OVWI can be charged as a felony if a person is seriously injured or if a death is a result of a DUI. A first-time DUI offender can be charged with a level 6 felony if serious bodily injury occurs as a result of the DUI. A level 6 felony is punishable up to 2.5 years in jail. If a person dies as a result of the DUI offense, well then the charges start as level 5 and can easily rise to level 4 depending on the amount of alcohol present or if there's controlled substances in the person's blood. A level 5 felony is punishable up to 6 years in jail, and level 4 is punishable by up to 12 years in jail. One of the most serious things I deal with on a daily basis is the habitual vehicular substance offender, or otherwise known as the HVSO. It's a sentencing enhancement, but basically if it's charged by the state, the HVSO adds 1 to 8 years to your maximum criminal sentence. For example, if you're charged with a misdemeanor DUI, the maximum sentence is typically 1 year. If you get a misdemeanor DUI and the state files the HVSO enhancement, you can actually go to jail for up to 8 years. Likewise, if you charge level 6 felony plus the HVSO, the maximum sentence is now 10.5 years in jail. The HVSO statute is one of the toughest DUI laws that Indiana has on its books. There are two ways to become eligible for the HVSO. The first option is where you're charged with a DUI and you have 2 priors, and at least one of those 2 prior DUIs is within 10 years of the current offense. The second way to be charged with the HVSO is if you have 3 prior DUIs and now you have a 4th. It doesn't matter how long ago the prior DUIs are. That 4th one makes you eligible for the HVSO. Now, this is a very serious charge because it can result in a rather lengthy prison sentence. This is also one of the charges that almost every county treats differently. In some counties, the HVSO will only be filed if and when negotiations fail. And once filed, these counties typically will not negotiate any further. Other counties will file this at the onset of a case, but will negotiate and take into account the time that is to be served as part of the global plea. No matter where a person is facing a DUI charge, if they're eligible to be charged as an HVSO, that person needs to be extremely proactive in dealing with their situation. If you have any questions, give me a call. 317-632-3642. Remember, always plead the 5th.